as I done more research into what they called commercial liens, because it shouldn't be called commercial liens. We'll get to that. But as I done more research, things got clearer and clearer and when it got clearer, the process got smaller, right? More precise. And that's really what we want, right? We want, as they used to say in the Marine Corps, I was in the Marine Corps, they used to say one shot, one kill, right? So just like David and Goliath, right? Oh man, I think I just had an epiphany. All these years, right? All of these years, I think I understand what the story of David and Goliath was about, right? So y'all probably say I'm not too bright because I just got this, right? But yeah, it doesn't really matter how big the giant is, right? If you have precision, and what you're doing is solid as a rock, we'll say that. And it doesn't take a whole lot. So the administrative process has gotten a whole lot smaller because we've been able to research to the point of where we have clarity and we're only going to deal with the things that matter, right? And all of this, I'm still talking about so-called commercial liens. Now, why is it a so-called commercial lien? Well, one is because I've never found the definition of commercial lien. And I've looked in Bouvier's and Black's Law Dictionary. I believe I did, at least. If you find the definition of commercial lien, let me know. I didn't find it in the UCC. I don't even think I really found a good definition on Google. But when you look in the dictionary and you look up liens, you see that there are equitable liens, statutory liens, and common law liens. And maybe they have some other variations, but I think what we are really looking at is an equitable lien. And then when we think of these in terms of equitable lien and what constitutes an equitable lien, the administrative procedure gets a whole lot simpler, right? So that's the approach that went into this, because we know in the Constitution they talk about law and equity. And it seems to me that most of what has been taught before on this administrative procedure to perfect a lien, it seems that the people who brought the teachings were trying to come from a common law standpoint, which might be some of the reasons why it's been difficult for us to put these liens together and present them in such a way where we really get enforcement, right? Because there's no equitable remedy under the law. So we're trying to use the common law lien to get a remedy in equity, if that makes sense. So that's just one reason why it doesn't jive. I just really don't feel like going to look this up right now. So I want to encourage you to take a moment while I take a sip of this coffee and go to Google and type in the elements of an equitable lien Cornell law. Type that into Google. It'll take you to that little breakdown and you'll read the elements of the equitable lien and you'll say, wow, it's basically just an administrative procedure and identifying the collateral under your security interests or your contract, and making sure that the person who you're dealing with has some type of duty or obligation to perform. These things are important, and we're going to overcome all of these things. But I mention them as being important because a lot of people don't really understand. They think that you could just send somebody a letter and say, if you don't respond in this amount of time, whatever, and then it's like binding on that person. Not really. It doesn't work that way. So people be putting all these default provisions in their contract. If you don't respond, you agree to blah, 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 blah. Not really. I just have to say it's yes and no, because you guys have the wrong idea sometimes with this type of thing. Most of the time. you know? So let's just say yes and no with that. If you had a real contract, yes, but the majority of the times you don't, not just because you wrote them a letter. We're now using the term equitable lien because that way, if you have any questions about what you're doing, you at least know where to go and research. Research what equity is and what an equitable lien is. All of this is about enforcement. So the equitable lien on the surety bond is the rest of the sentence, right? The equitable lien on the surety bond. In order to have a lien, right, there has to be a contract from which the lien arises, right? So the contract is your acceptance of the oath of office. I'm being in general because everybody's not going to have an oath of office, but a lot of people will that we have to deal with, right? So I accept your oath of office. If you're doing this in real time, like talking to the person, it'd be good to have a witness with you because a public official with the oath is going to acknowledge your acceptance. If you're doing it in writing, you should do it registered mail. And when an offer is made and an acceptance is made, that is the offer acceptance. So that is the contract. That's the offer and that's the acceptance. The consideration for the offer, in this case, the offer being the pledge or the oath, is the surety bond. The consideration is the oath of office, the pledge itself, and the collateral. Somewhere between the consideration and the collateral and the proceeds is the oath of office and the surety bond. So all of those things happen with your acceptance of the oath of office. And this is the interesting thing, a small little detail. I'm thinking about it. You guys probably can care less about it. But it's amazing that that contract, the offer of a public official, is always there on the table to support and defend the Constitution of the United States and the laws and whatever else they say in there. We should go check it out because that is always out there in the public, let's say with their signature on it. And maybe there is a signature, maybe there's not a signature. I'm just saying this so you can see that at any time you can accept that oath of office and create a binding and enforceable contract, especially if what you're doing is lawful. If what you're not doing is lawful, you probably shouldn't be doing it. I'm going to put these case laws on the screen here. These are some case laws. The Supreme Court has held in numerous cases, for example, in the case of the United States versus E-Ray, the Supreme Court held that an oath is a binding contract and that breaking it is a crime. Additionally, in the case of the United States versus Goldberg, the Supreme Court held that an oath is legally binding agreement and that breaking it is a violation of the law. So the Supreme Court in one instance said that an oath is a binding contract, and breaking it is a crime. And in another instance, the Supreme Court said, in the United States versus Goldberg, the Supreme Court held that an oath is a legally binding agreement. That's what I was trying to tell you, right? And that breaking it is a violation of the law, right? So that's cool right there because now they're saying it's breaking the oath is a violation of the law. So we're not even talking about equity now. Now we're back into the law. This is something to pay attention to, right? It is well established that the acceptance of the oath of a government officer can create an enforceable contract. This is supported by case law such as Palco versus Connecticut, 302 U.S. 319, 1937, where the U.S. Supreme Court held that a contract based on a government officer's oath was valid and enforceable. This is what we're going to be talking about. A contract based on an oath that we've accepted for value. What is the contract? It's called the Fiduciary Appointment and Authorization Contract. First, we have the 15 USC. It's been so long since I looked at this that I'm probably going to do a poor job of explaining exactly what it is, but I know it needs to be here, and maybe I can't express it right now. But what it basically is, this is an identifier. It's like a marker. And what it is, it's like a flag, right? That's how we could look at it. It's like a flag on your, it is a flag, obviously. It's called a tracer flag. So why would you have a flag? Maybe because the document is a vessel, right? And this particular flag identifies this affidavit, right? Because when you think of the affidavit, you're thinking of the law, right? It's an affidavit. It's persons under the common law or whatever. It's affidavit. But in this particular case, this affidavit is a security. It's a charging instrument, right? It has something to do with money or funny money or equity or a charge, basically, commerce, if you will. So this is what this flag is saying. Usually when you see these, it says like 15 USC tracer, not a point of law. What is 15 USC? I don't really feel like going there. It probably says securities or something. Probably does. I think that is securities. I don't know. Forgive me if I'm wrong. Just don't feel like going there right now. But you can go do some more research on it. But that's what the tracer flag is. So maybe certain organizations like the Securities Exchange Commission, I think maybe they track it. So if this gets in some government record somewhere, they will probably track it. Maybe because of reporting, who knows, financial reporting, whatever. But this is just typically, that's also in line with letting them know this is a charge, this is a security interest. So if it's a security interest, I guess it would be the estate trust who's the issuer of this security. So anyway, that's what that is. And you may want to, since it is a security, you may want to send it registered mail, right? You may want to send this to the lienee registered mail. And you don't have to prove that they received it and all of that. I don't really think you have to, because this lien, once it's executed, it's done. This is already after numerous defaults. But yeah, since it is a security, you could give it a registered mail number and go ahead and send it to the lienee. Now, this is a claim of lien for $10 million in this example. Any $10 million lien will vastly exceed the surety bond. I'm not sure if it's strategic to exceed the surety bond with your claim or to max it out, or if it matters one way or the other. Your claim should be your claim. And usually most of any claim that we make will max out a surety bond, because surety bonds is usually like 50,000, 100,000. I seen one for 500,000 one time. Right? But claims aren't usually made on these things. And you shouldn't make a claim on a surety bond unless you know what you're claiming is eligible. You really have to understand it. You can't just move on these things because you're upset, right? Or somebody did something wrong to you, so you just want to get him back, but you really don't understand, but you just know that, man, if I could make a claim on their bond. Nah, you have to be able to cross your T's, dot your I's, connect the dots, and put this thing together so that if you do have to file a lien on someone's surety bond or remove them from office, that you're able to stand on it. This is where I was trying to go with this whole long rant, rave, and conversation. It's right in front of us. It's the affidavit. The affidavit. This affidavit written as a charge, as a lien. This is the execution of a lien right. Excuse me. You didn't have to ask permission to record this lien, this property interest that you secured through your private contract with that fiduciary. The fiduciary is a public officer, but not when you appoint them as a fiduciary. That's a private contract between you and them. There's no third parties in that contract. So you have the right to execute that lien in the fiduciary's property, which is a surety bond. And then that does have a third party right there because of the surety bond has a guarantor, you know. But the issue is that the claim that we're making, right? If you made a claim with the IRS, they'll say make it on a 1040, right? If you made a claim with the Social Security Administration, they'll give you some other type of form. Everybody has a form to make a claim. The form of our claim is in the, or I should say, our claim is in the form of what? An affidavit. Our claim of lien is in the form of an affidavit, and it's based off of a private contract between party A and party B, who happens to be an elected official. Why am I saying this? Because our claim is in the form of an affidavit, their response must be in the form of an affidavit to prevent a default, right? Actually, there's already a default. This is not even a process, but let's say still, you want to remove this lien, you have to respond by affidavit, because really that's what we're looking at. It's an affidavit. So even though it is a lien, right? You see, it looks like a, looks like a lawsuit. How we got it set up here. We got the claim of lien. We got the surety bond number and all this. But when we go down here and look at the substance, we're looking at an affidavit. Now that's a problem right there, because you can't just go removing people's affidavits. Let's read it. Let's read the first part. This affidavit is a legal expression of my right to petition the government for redress and is protected under the First Amendment of the United States Constitution. Any third party who attempts to cancel, remove, mutilate, obliterate, or nullify this affidavit in any way must provide an affidavit of their own, sworn or affirmed under penalty of perjury, to rebut and support their claim. Said third party's affidavit shall express their lawful basis and authority for making their counterclaim or other determination. Failure to respond in accord with the requirements will result in said third party being added to this claim as a lien debtor. Right? They get added right up here.